I stared at the dry irrigation lines running across my cattle ranch in Montana, watching 300 head of Angus cows milling around empty water troughs under the August sun, and knew that Patricia Henderson from the Clearwater Hills HOA had finally crossed a line that would cost her everything. My name is Franklin Sutherland, and I had owned this 500-acre working ranch outside Billings for 15 years before some developer decided to build a luxury housing community along the eastern border of my property. That was 3 years ago, and ever since Patricia Henderson took over as HOA president 18 months back, my life had become a living nightmare of complaints, citations, and harassment that would make any reasonable person lose their mind. The morning started like any other Thursday in late summer. I woke up at 5, made coffee, and headed out to check on the cattle before the heat really kicked in. Montana summers can be brutal, and with temperatures pushing into the high 90s, keeping the livestock hydrated was critical. I drove my truck along the fence line, noting that everything seemed normal until I reached the main water distribution point near the eastern pasture. That is when I noticed the silence, no water flowing through the pipes, no familiar hiss of liquid moving through the irrigation system. Just dead, awful silence. I jumped out of the truck and ran to the main valve station, which sat about 50 yards from the property line I shared with Clearwater Hills. What I found made my blood run cold. The main shutoff valve, which controlled water flow to my entire eastern pasture and the holding pens, had been turned completely off. But that was not even the worst part. Someone had wrapped a heavy chain around it and secured it with an industrial padlock. Attached to the chain was a laminated notice on HOA letterhead. Notice of Water Access Restriction, it read in bold letters. Per Clearwater Hills, HOA Covenant Section 47B, this water line has been deemed in violation of community aesthetic standards and poses potential drainage issues affecting HOA properties. Water access is hereby restricted pending compliance review. Contact HOA President Patricia Henderson for remediation requirements. I read it 3 times, certain I was hallucinating from the early morning heat. This water line had been on my property for 20 years. It connected to a well I had drilled myself, using water rights I had purchased legally through the state. The HOA had absolutely no jurisdiction over my ranch, my water, or anything else I did on my land. Yet here was physical evidence that Patricia Henderson thought otherwise. I pulled out my phone and called my ranch manager, Tommy Martinez, who had worked with me for the past decade. Tommy, get out to the eastern valve station right now. We have a serious problem. He arrived 15 minutes later in his dusty Ford, took one look at the locked valve, and let out a long string of curses in Spanish and English. Boss, this is insane. How can they even do this? This is your property, your water. They cannot, I said, my jaw clenched so tight it ached, which is exactly why I am about to make a phone call that Patricia Henderson is going to regret for the rest of her life. I had dealt with Patricia's nonsense before. It started small, like most HOA horror stories. First came the letter complaining about the unsightly appearance of my barn, which was visible from some of the HOA homes. Never mind that my barn had been standing since 1987, decades before her precious community existed. Then came complaints about dust from my dirt roads, noise from cattle, the smell of manure, and my personal favorite, that my ranch vehicles were commercial equipment that violated some imaginary aesthetic standard she claimed extended to properties visible from HOA homes. I had ignored most of it, responded politely to some, and consulted a lawyer about the rest. My attorney, Richard Brennan, had sent her several cease and desist letters explaining that HOA covenants do not apply to non-member properties and that she needed to stop harassing me. So apparently, Patricia decided that letters from lawyers were just suggestions. Now she had committed what I was pretty sure was both trespassing and property damage by physically interfering with my water supply. With 300 cattle depending on that water and temperatures climbing, this was not just harassment anymore. This was potentially criminal. I dialed Richard Brennan's office. His receptionist, a pleasant woman named Diane, answered on the second ring. Brennan Law Office, how may I help you? Diane, this is Frank Sutherland. I need to speak with Richard immediately. It is an emergency. Let me check if he is available, Mr. Sutherland. She put me on hold for maybe 30 seconds before Richard picked up. Frank, what is wrong? Richard was in his mid-50s, a former prosecutor who had transitioned into private practice specializing in property law and civil litigation. We had known each other for years, and he could tell from my tone that this was serious. I explained the situation, describing the locked valve, the notice, and the immediate danger to my livestock. Richard was silent for a moment after I finished, and when he spoke, his voice had that particular edge that told me he was already mentally preparing for court. Frank, do not touch that lock. Take photos of everything, especially that notice. Document the valve, the chain, everything. I'm going to make some calls and then I'm driving out there. This is beyond harassment now. This is criminal trespass, destruction of property, and possibly animal endangerment. How long can your cattle go without water to that section? In this heat? Not long. Maybe 24 hours before we start seeing real problems. I can truck water in temporarily, but Richard, I have 300 head out here. That is not sustainable. I understand. Give me 2 hours. In the meantime, call the sheriff's office and file a report. This is a crime scene now. I hung up and immediately dialed the Yellowstone County Sheriff's Department. The dispatcher took my information and promised to send a deputy out within the hour. Then I called Tommy back over. Get the water truck ready. We are going to have to manually fill those troughs until we get this sorted out. And call Jake and Martin. We are going to need all hands on deck. The next hour was a blur of activity. Tommy and our other ranch hands started the laborious process of trucking water from our western well to the eastern pastures. It was inefficient, time-consuming, and expensive, but it would keep the cattle alive while we fought this legal battle. A sheriff's deputy named Cooper arrived around 8 in the morning, took my statement, photographed everything, and confirmed what I already knew. This was trespassing and property damage at minimum. Mr. Sutherland, I have dealt with this HOA before, Deputy Cooper said, shaking his head as he wrote in his notebook. We have had multiple complaints from other property owners in the area. This Henderson woman seems to think she has authority over the entire county. I will file this report, and the detective unit will follow up. You mentioned your attorney is coming? Should be here within the hour. Good. You're going to need one. In the meantime, do you have bolt cutters? Because legally, that is your property, your valve, and you have every right to remove that lock. I did have bolt cutters, but Richard had told me not to touch anything yet. I want to wait for my lawyer, make sure we document everything properly for court. Deputy Cooper nodded approvingly. Smart thinking. Let me know if you need anything else. He handed me a case number and left, just as Richard's silver Lexus pulled up the dirt road. Richard emerged wearing jeans and a polo shirt rather than his usual suit, ready for ranch work. He had brought his paralegal, a sharp young woman named Lisa Chen, who immediately began taking photographs and measurements of everything. Richard examined the lock, read the notice, and I watched his expression darken with each passing second. Frank, this is one of the most egregious cases of HOA overreach I have seen in my 25 years of practice, he said, looking up from the notice. They have trespassed on your property, damaged your infrastructure, and endangered your livestock. The fact that they were stupid enough to leave a signed notice makes this almost too easy. Almost? I asked. Well, we still have to prove damages, fight the court battle, and deal with whatever nonsense they throw at us in response. But Frank, I am not going to lie to you. This is a case I have dreamed of taking to trial. These HOA tyrants need to learn that they cannot just bully people outside their jurisdiction. Lisa finished her documentation and approached us. I have everything we need, including measurements showing the valve is clearly on Mr. Sutherland's property, approximately 80 feet from the actual property line. Richard nodded. Perfect. Frank, here is what we're going to do. First, we are cutting that lock off right now because your cattle need water and we have documented everything. Second, I am filing an emergency motion for a restraining order against Patricia Henderson and the HOA board, prohibiting any further interference with your property. Third, we are suing them for trespassing, property damage, economic damages, and punitive damages. I'm thinking we start at $2 million and see where it goes. My eyes widened. $2 million? Frank, they cut off water to 300 head of cattle in August. Do you know what could have happened if you had not noticed until later in the day? You could have lost livestock. You are losing money right now trucking water. You are going to continue losing money until this is resolved. Plus, this is clearly part of a pattern of harassment we have documented over 2 years. Yes, 2 million is appropriate, and honestly, I think we can prove every penny. I retrieved the bolt cutters from my truck while Richard called the sheriff's department to inform them we were removing the lock as it was on my property and interfering with my livestock operation. Deputy Cooper had apparently noted in his report that this was acceptable, so we had official blessing to proceed. The chain fell away with a satisfying snap of the cutters, and I turned the valve back on. The sound of water rushing through the pipes was the most beautiful thing I had heard all day. We walked back to the troughs and watched them begin to fill, cattle already pushing forward to drink. "I want to meet this Patricia Henderson," Richard said, watching the scene with satisfaction. "Face to face, on the record. Are you free this afternoon?" "I can be. What do you have in mind?" "I'm going to call an emergency meeting with the HOA board. As your attorney, I'm going to formally notify them of the lawsuit and give them one chance to settle this before it gets really ugly for them. I doubt they will take it, but legally, I have to offer." Richard made the call right there, standing in my pasture. I could only hear his side of the conversation, but it was enough. "Ms. Henderson, this is Richard Brennan, attorney for Franklin Sutherland. I'm calling to inform you that you and the Clearwater Hills HOA are being sued for trespassing, property damage, and multiple other violations related to your illegal interference with Mr. Sutherland's ranch operations this morning. I am also filing for an emergency restraining order within the hour. I would like to meet with you and your board at 2 o'clock this afternoon to discuss a potential settlement before this goes to court. Will you be available?" I could not hear Patricia's response, but Richard's face told me it was not pleasant. "Ms. Henderson, I would strongly advise you to consult with your HOA's legal counsel before making any statements. Yes, 2 o'clock. Clearwater Hills Community Center. I will see you there." He hung up and looked at me with something between amusement and disbelief. She told me, and I quote, that she has every right to enforce community standards on properties that affect HOA home values, and that you have been a nuisance to her community since the day it was built. She also said she is looking forward to seeing us in court because her HOA attorney will make short work of this frivolous lawsuit. She really said frivolous? She really did. "Frank, I think you need to come to this meeting. I want you to see what we are dealing with, and I want them to see that you are serious about this." At 2 o'clock, Richard, Lisa, and I walked into the Clearwater Hills Community Center, a pretentious building with marble floors and chandeliers that seemed wildly out of place for a Montana housing development. Patricia Henderson was already there, seated at the head of a long conference table like she was chairing a corporate board meeting. She was exactly what I expected, mid-50s, blonde hair and that stiff helmet style that screamed, "Can I speak to your manager?" wearing too much makeup and a pink blazer that probably cost more than I paid my ranch hands in a week. Flanking her were 4 other board members, all looking uncomfortable, and a nervous-looking man in his 30s who introduced himself as Graham Foster, the HOA's attorney. Graham looked like he had been pulled into this meeting without much context, and the color drained from his face when Richard laid out the documentation of what the HOA had done. "Let me make sure I understand this correctly," Graham said, flipping through the photographs Lisa had printed. "You, Ms. Henderson, authorized HOA members to go onto Mr. Sutherland's property, locate his water valve, and lock it closed." "I authorized enforcement of our community standards," Patricia said, her voice dripping with condescension. "That water line creates drainage issues that affect our properties, and the unsightly pipes are visible from several homes. We have every right to protect our property values." "Ms. Henderson," Graham said, and I could hear the barely controlled panic in his voice. "Mr. Sutherland's ranch is not part of our HOA. His property is not subject to our covenants. You cannot enforce HOA rules on non-member properties." "Those rules apply to anything that affects our community," Patricia snapped. "I have been president of this HOA for 18 months, and I have improved property values by 15% by strict enforcement of standards. I am not going to let some rancher ruin that because he thinks he is above the rules." Richard leaned forward, his expression deadly serious. "Ms. Henderson, let me be very clear about your legal situation. You have committed criminal trespass, property damage, and potentially animal endangerment. You have interfered with a legal water rights holder's access to his own water on his own property. You have caused my client significant economic damages, and you have done all of this while leaving a signed notice admitting to these actions. Do you understand that you could face criminal charges? I understand that you are trying to bully this board with legal threats, Patricia said. We have insurance for this kind of thing. Our HOA attorney will handle it. Graham looked like he wanted to disappear into the floor. Ms. Henderson, our HOA insurance does not cover willful illegal acts by board members. If you deliberately trespassed on someone's property, that is not covered. And I need to tell this board right now that I strongly advise accepting any reasonable settlement offer because we cannot win this case. Cannot win? Patricia's voice went up an octave. We have every right to protect our community. I have documented every single violation this ranch has committed against our aesthetic standards. The noise, the smell, the dust, the ugly equipment. None of which gives you jurisdiction over his property. Graham was nearly shouting now, and the other board members were looking at each other with growing alarm. You cannot enforce HOA rules on property that is not in the HOA. This is basic property law. Then the law needs to change, Patricia said stubbornly. I'm not backing down on this. Richard pulled out a document from his briefcase. Then let me present you with this notice of lawsuit, filed this morning in Yellowstone County District Court. We are seeking $2 million in damages, plus attorney fees, plus injunctive relief prohibiting any further harassment of Mr. Sutherland. Discovery will include all HOA communications, emails, meeting minutes, and financial records. The trial will be public record. Every homeowner in your community will know that their HOA fees are being spent on defending an indefensible lawsuit that their president initiated by committing crimes. One of the other board members, an older man with gray hair, spoke up for the first time. Patricia, this is insane. I did not sign up for this when I joined the board. We need to settle this and settle it now. Howard, you are being dramatic, Patricia said dismissively. This rancher is trying to intimidate us. We are not paying him a dime. Actually, Richard said, I'm offering you a settlement right now. Before this goes any further, Mr. Sutherland will agree to drop the lawsuit if the HOA pays him $50,000 for his damages and legal fees, issues a formal written apology, and Patricia Henderson resigns as HOA president immediately. That offer expires when I walk out of this room. The other board members looked at Patricia, then at each other. Howard spoke again. Patricia, we need to take this offer. This is a disaster. I am not resigning, Patricia said flatly, and we are not paying this man anything. Meeting adjourned. She stood up and walked out, leaving Graham Foster sitting at the table with his head in his hands. The other board members scattered, except for Howard, who approached us quietly. Mr. Sutherland, Mr. Brennan, I want to apologize, he said, looking genuinely distressed. Many of us on the board have been trying to rein in Patricia for months, but she has a voting bloc of supporters who back her no matter what. I'm going to call an emergency board vote to remove her, but I cannot promise it will work. In the meantime, please know that not all of us support this craziness. I appreciate that, Howard, I said, but at this point, it is too late for apologies. She committed crimes on my property and endangered my livestock. This is going to court. Howard nodded sadly and left. Graham Foster approached us, looking defeated. Mr. Brennan, off the record, I am going to resign as HOA counsel after today. I cannot defend this. I will recommend they hire someone else, but I'm going to tell them the same thing I told them today. Settle this case for whatever you are asking, because they cannot win. Richard shook his hand. I appreciate your integrity, Graham. Not many lawyers would walk away from a paying client. I have a reputation to maintain, Graham said, and I'm not going to destroy it defending Patricia Henderson's ego trip. We left the community center and stood in the parking lot, watching HOA residents walking their dogs and tending their immaculate lawns. It all looked so perfect and peaceful on the surface, with no hint of the tyranny lurking underneath. Richard, do you really think we can get $2 million? I asked. Frank, I think we can get more if we play this right. Patricia Henderson just made the biggest mistake of her life, and she does not even know it yet. Now comes the fun part. Discovery. Over the next 3 weeks, the case transformed from a property dispute into a full-scale legal war. Richard filed the emergency restraining order, which was granted immediately by Judge Monica Reeves, prohibiting the HOA from any further interference with my property or operations. Patricia violated it twice, first by sending me another citation for unsightly fence repairs, and then by calling the county zoning office with false complaints about illegal structures on my ranch. Each violation was documented, reported to the court, and added to our growing pile of evidence. Judge Reeves was not amused. At a hearing on the third week after the initial incident, she called Patricia to the stand and asked her directly why she seemed unable to follow a court order. "Your Honor, I am simply trying to maintain standards in my community," Patricia said, somehow managing to sound both defensive and condescending. "Mr. Sutherland's ranch activities continue to negatively impact our property values." "Ms. Henderson," Judge Reeves said, her patience clearly wearing thin, "I'm going to explain this one more time. Mr. Sutherland's property is not part of your HOA. You have no authority over his property. The restraining order prohibits you from contacting him, sending him citations, or interfering with his property in any way. If you violate this order again, I will hold you in contempt of court, which means jail time. Do you understand?" "Yes, Your Honor," Patricia said, though her expression suggested she understood nothing of the sort. The discovery phase was even more revealing than Richard had anticipated. When we subpoenaed HOA records, we discovered that Patricia had been running the HOA like her personal fiefdom. She had approved expenditures without board votes, hired her brother-in-law's company for maintenance work at inflated prices, and kept sloppy financial records that suggested possible embezzlement. But more importantly for our case, we found emails. Richard called me into his office on a Tuesday afternoon in early September, looking like a kid on Christmas morning. "Frank, you need to see this." He turned his laptop around to show me an email chain between Patricia and several board members. The first email, dated 6 months earlier, was from Patricia to the board. "The Sutherland Ranch continues to be an eyesore and nuisance to our community. I propose we begin aggressive enforcement actions to pressure him into either selling or limiting operations. If we make things difficult enough, he will eventually give up. Our property values will increase significantly if we can get that ranch to shut down or relocate." Another board member, a woman named Cheryl, had responded, "Patricia, I don't think we have authority to enforce anything on his property. Maybe we should consult with our attorney first." Patricia's response, "We have authority to protect our community's interests. I will handle the legal aspects. Your job is to support the board's decisions." The email chain continued for months, documenting Patricia's escalating plans to harass me into submission. There were discussions about filing false complaints with county agencies, spreading rumors about my ranch to affect my business relationships, and ultimately, the plan to shut off my water. "This is conspiracy," Richard said, grinning. "Documented conspiracy to interfere with your business and property rights. Frank, this just went from a good case to a slam dunk. She put everything in writing." "Can we add this to the lawsuit?" I asked. "Already drafting an amended complaint. We are adding tortious interference with business relationships, conspiracy, intentional infliction of emotional distress, and I am seriously considering adding a RICO claim." "RICO? Like organized crime?" "RICO applies to patterns of illegal activity, not just organized crime. If we can show a pattern of extortion and harassment, it fits. Plus, RICO allows for treble damages, meaning we could triple whatever the jury awards. I am thinking we might want to increase our demand to $5 million. I let out a low whistle. "Richard, I appreciate the enthusiasm, but I'm a rancher, not a lottery winner. I just want them to leave me alone and pay for the damage they caused. And they will. But Frank, this is bigger than just your case now. Patricia Henderson has been doing this to other people too. During discovery, I found complaints from 3 other property owners in the area, all subjected to similar harassment. If we can crush her in court, it sends a message to every HOA tyrant in Montana that they cannot behave this way. Besides, the insurance company will end up paying most of it, not the individual homeowners." "I thought Graham said their insurance would not cover this." "It won't cover Patricia's personal liability, but it will cover the HOA's institutional liability for the actions of its president. Trust me, the insurance company is going to settle once they see this evidence. They are not going to let this go to trial." Richard was right. 2 days after we filed the amended complaint with all the email evidence attached, the insurance company's attorney called requesting a settlement conference. Her name was Jennifer Walsh, a senior litigator from a firm in Denver, and she sounded exhausted when Richard put her on speakerphone in his office. "Mr. Brennan, I have reviewed the evidence in this case, and I need to tell you that my client, Rocky Mountain HOA Insurance Group, is prepared to discuss settlement within reason. However, I need to be clear that we are not going to pay $5 million for what is essentially a property dispute." "Ms. Walsh, this is not a property dispute," Richard said calmly. "This is documented conspiracy, criminal trespass, business interference, and a pattern of harassment spanning 2 years. Your insured's president left a paper trail that a first-year law student could prosecute. If this goes to trial, a Montana jury is going to see a wealthy HOA bullying a working rancher, and they are going to hammer you. I understand your position, but $5 million is not reasonable. We are prepared to offer $250,000 to settle all claims." I watched Richard's expression and knew he was enjoying this. "Ms. Walsh, let me walk you through what trial's going to look like. Day 1, we show the jury photos of 300 cattle standing around empty water troughs in August heat. Day 2, we show them emails where Ms. Henderson admits she is trying to force my client out of business. Day 3, we bring in the other property owners she has harassed. Day 4, we bring in a forensic accountant who will testify about possible embezzlement from HOA funds. By day 5, the jury is going to want to award us more than $5 million. So no, $250 is not reasonable. Come back when you are serious about settling this case." There was a long silence on the phone. "Give me a week to discuss this with my client. But Mr. Brennan, I need you to understand that there are limits to what insurance will cover. Ms. Henderson's personal actions are not covered by the policy." "I understand perfectly," Richard said, "which is why we are also pursuing personal liability against Ms. Henderson. If your insurance does not cover it, she will pay out of pocket. Frankly, Ms. Walsh, your best move is to settle the HOA's portion for a reasonable amount and let Ms. Henderson hang on her own." After Jennifer Walsh hung up, I turned to Richard. "You think she will come back with a better offer?" "Absolutely. Insurance companies do not want to go to trial on cases like this. The discovery has been a nightmare for them, and it is only going to get worse. My guess is they will come back around $1.5 million within 2 weeks. The question is whether we take it or push for trial. What do you recommend?" Richard leaned back in his chair, considering. "Honestly, I would love to take this to trial because I think we would win big, and it would send a message. But trials are expensive, time-consuming, and unpredictable. If they offer 1.5, I would recommend taking it. That is enough to compensate you for damages, cover legal fees, and still hurt them badly enough that Patricia Henderson's reign of terror is over." While we waited for the insurance company's response, the criminal case against Patricia was also moving forward. The Yellowstone County District Attorney's Office had reviewed Deputy Cooper's report and decided to file charges: criminal trespass, criminal mischief, and reckless endangerment. The reckless endangerment charge was the serious one, a felony based on the fact that cutting off water to livestock in August heat could have resulted in animal deaths. I attended Patricia's arraignment in late September, watching from the gallery as she stood before Judge Thomas Wilcox, looking significantly less confident than she had at the community center. Her criminal defense attorney, a public defender named Mark Stevens, entered a not guilty plea and requested a trial date. Bray. "Ms. Henderson," Judge Wilcox said, reviewing the charges, "I am releasing you on your own recognizance, but I am adding a condition. You are to have no contact with Mr. Sutherland, his property, or his business operations. You are also prohibited from acting in your capacity as HOA president in any matter related to Mr. Sutherland or his ranch. Do you understand these conditions?" "Yes, Your Honor," Patricia said quietly, the first time I had heard her speak without that edge of superiority. Outside the courthouse, a reporter from the Billings Gazette approached me. The story had made local news, and people were fascinated by the idea of an HOA president facing felony charges. "Mr. Sutherland, do you have any comment on today's arraignment?" The reporter, a young woman named Amanda Price, asked. "I am satisfied that the justice system is taking this seriously," I said carefully, aware that anything I said could affect both cases. All I ever wanted was to run my ranch in peace. I hope this sends a message that HOA boards cannot just do whatever they want at people outside their communities. Have you received any support from other property owners in the area? I have received dozens of calls and emails from people who have dealt with similar harassment from HOAs. This is not just about me. This is about property rights and the limits of HOA authority. The story ran the next day with the headline, "Rancher Fights Back Against HOA Overreach." The article detailed the case, included quotes from both sides, and mentioned the criminal charges. Within hours, it had been picked up by regional news outlets, then national news websites. Suddenly, my fight with Patricia Henderson was being discussed on property rights blogs, HOA reform forums, and even cable news shows. The publicity had an interesting effect. Howard called me directly, which technically violated the restraining order's prohibition on HOA contact, but Richard advised me to take the call and document it. "Mr. Sutherland, this is Howard Williams from the HOA board. I know I am probably not supposed to contact you, but I needed you to know that we finally got the votes. Patricia Henderson has been removed as HOA president. The board voted 7-3 this morning to terminate her position, effective immediately. I appreciate you letting me know, Howard, but you understand this does not change the lawsuit, right? The damage has been done. I understand completely. I just wanted you to know that we are trying to fix things. I have been elected interim president, and my first action was to fire our new attorney and hire someone who actually understands property law. We are going to formally withdraw all citations and complaints ever issued to you, and I am personally apologizing for everything that has happened. I know it does not make up for what Patricia did, but I want you to know some of us in the community respect what you do and have no problem with your ranch. Thank you." "But, Howard, that means something. But you are right, it does not change the legal situation. Patricia Henderson committed crimes, and the HOA is liable for her actions while she was president." "I know. Our new attorney told us the same thing. He is preparing a settlement proposal for your lawyer. I hope you will consider it fairly." The settlement proposal arrived 3 days later. The HOA, now under new leadership and new legal counsel, was offering $1 million to settle all claims against the HOA itself, with a formal written apology to be published in the community newsletter and posted on the HOA website. The offer included an agreement that the HOA would never again issue any citations, complaints, or communications to me regarding my ranch operations. Separately, the insurance company increased their offer to $1.3 million, covering both the HOA's institutional liability and their defense costs. Combined with the HOA's direct offer, we were looking at $2.3 million. Richard and I met in his office to discuss the offer. "Frank, this is a good settlement. It is more than your actual damages. It punishes them sufficiently for what they did, and it ends this without the uncertainty of trial. The only thing we lose is the chance to crush them in front of a jury, but honestly, they are already crushed. Patricia is gone. They are out millions of dollars, and every HOA in the state knows about this case." "What about Patricia personally?" I asked. "We are still pursuing personal liability against her separately. The settlement only releases the HOA and the insurance company. We can continue the civil case against Patricia for punitive damages, and she still faces criminal charges. She is not getting off easy." I thought about it for a long moment. The money was honestly more than I had expected. I had gone into this fight because I was angry and wanted justice, not because I wanted to get rich. But Richard was right that the settlement accomplished our goals. "Let's take it," I said finally. "But I want that written apology to be specific. I want them to admit that they had no authority over my property, that their actions were wrong and illegal, and that they apologize not just to me, but to the community for wasting HOA funds on Patricia Henderson's personal vendetta. I will draft the language and send it to their attorney. If they agree, we can have this wrapped up by the end of October." The HOA agreed to Richard's proposed apology language without changes. On October 28th, the settlement was finalized. The HOA paid $1 million directly, the insurance company paid $1.3 million, and a detailed apology was published both in print and online. I kept a copy of it framed in my ranch office. To the Clearwater Hills community and to Mr. Franklin Sutherland, the Clearwater Hills Homeowners Association acknowledges that under the former presidency of Patricia Henderson, the HOA engaged in a pattern of harassment and illegal actions against Mr. Sutherland and his lawful ranch operations. These actions included criminal trespass, property damage, false complaints to government agencies, and interference with Mr. Sutherland's water rights. The HOA had no legal authority to enforce its covenants on Mr. Sutherland's property, which is not part of our association. We deeply apologize to Mr. Sutherland for the stress, expense, and damage caused by these actions, and we apologize to our community members for the misuse of HOA funds and authority. Under new leadership, this HOA will respect property rights and operate within the bounds of the law. The civil case against Patricia personally was still pending, but her criminal trial was scheduled for November. Richard advised me to attend, as my testimony would be crucial to the prosecution's case. The trial lasted 3 days. The prosecutor, an assistant DA named Sarah Mitchell, built a methodical case showing exactly what Patricia had done, why it was illegal, and the potential harm it could have caused. I testified on the second day, walking the jury through the discovery of the locked valve, the immediate danger to my livestock, and the economic damage I had suffered. Patricia's defense attorney tried to argue that she had genuinely believed she had authority to enforce HOA standards and that there was no criminal intent. It was a weak defense, and the jury saw through it. On the third day, after only 2 hours of deliberation, they returned guilty verdicts on all charges. Judge Wilcox scheduled sentencing for 3 weeks later. In the meantime, Patricia's life had fallen apart in other ways. Her husband filed for divorce, citing the embarrassment and financial liability from her actions. Several families in Clearwater Hills filed a class action lawsuit against her personally for the decrease in their property values due to the scandal and the HOA's financial payout. And her social media accounts, which she had used to brag about her strict enforcement of HOA standards, became museums of public mockery. I attended the sentencing hearing in early December. The courtroom was packed with reporters, Clearwater Hills residents, and other property owners who had dealt with HOA harassment. Judge Wilcox took the bench and reviewed the pre-sentence report before addressing Patricia. "Ms. Henderson, you have been convicted of criminal trespass, criminal mischief, and reckless endangerment. These charges arise from your decision to enter Mr. Sutherland's property without permission and shut off his water supply, endangering his livestock and interfering with his legal rights. I've read the pre-sentence report, the victim impact statements, and the letters submitted on your behalf. I've also reviewed the civil lawsuit and the evidence of your pattern of harassment against Mr. Sutherland and others." He paused, looking directly at Patricia. "What troubles me most about this case is your complete lack of remorse. Even now you seem to believe you were justified in your actions because you were protecting your community. But Ms. Henderson, you were not protecting anyone. You were abusing your position as HOA president to bully someone whose lifestyle you disapproved of. You committed crimes, you lied to government officials, and you endangered animals because you wanted to impose your will on property you had no authority over." Patricia stood silently, her lawyer beside her, but I could see tears running down her face. "For the charge of reckless endangerment, a felony, I sentence you to 2 years in the Montana Women's Prison, suspended, with 5 years of supervised probation. For criminal trespass and criminal mischief, I sentence you to 1 year in the county jail on each count to run concurrently with your probation. I am also ordering you to pay full restitution to Mr. Sutherland in the amount of $75,000 for damages not covered by the civil settlement, and I am ordering 1,000 hours of community service to be completed at an animal sanctuary." The courtroom erupted in whispers. A suspended sentence meant Patricia would not go to prison unless she violated probation, but the felony conviction meant she was now a convicted felon with all the consequences that entailed: loss of voting rights, difficulty finding employment, and a permanent criminal record. Additionally, Judge Wilcox continued, as a condition of your probation, you are permanently prohibited from serving on any HOA board or in any position of authority within a homeowners association. You are also prohibited from any contact with Mr. Sutherland or his property for the duration of your probation. Patricia's attorney stood. Your Honor, my client requests permission to make a statement. Judge Wilcox nodded. Patricia stood, shaking, and turned to face me directly. Mr. Sutherland, I am sorry, she said, her voice breaking. I thought I was doing the right thing for my community, but I was wrong. I let my need for control take over, and I hurt you and endangered your animals. I have lost everything because of my actions, and I deserve that. I just want you to know that I am truly sorry. I looked at her for a long moment. Part of me wanted to say something harsh, to tell her exactly how much stress and pain she had caused me. But looking at her now, broken and crying, I realized she had already lost everything that mattered to her. Her position, her reputation, her marriage, her freedom. Adding to her misery would not make me feel any better. I accept your apology, I said simply. I hope you learn from this and never treat anyone this way again. Judge Wilcox concluded the hearing, and I walked out of the courthouse into the cold December air. Richard was waiting outside with Lisa, both of them looking satisfied. That went as well as we could have hoped, Richard said. She is a convicted felon. She's on probation for 5 years, and she can never terrorize another HOA community. Plus, you have your settlement money and additional restitution. Frank, you won this fight completely. It does not feel like winning, I said honestly. It feels like a lot of wasted time and energy on something that never should have happened in the first place. That is why cases like this matter, Richard said. Because maybe the next Patricia Henderson will think twice before harassing someone outside her jurisdiction. Maybe some HOA board member will remember this case and say no when the president suggests doing something illegal. You fought back, Frank, and that matters. Over the next few months, life slowly returned to normal at the ranch. The water flowed freely, the cattle thrived, and I heard nothing from Clearwater Hills except occasional friendly waves from residents when I drove past their community. Howard kept his word about leaving me alone, and the new HOA board seemed content to manage their own properties without worrying about mine. The case made a lasting impact beyond just my situation. The Montana legislature actually passed a new law in the following session, nicknamed the Sutherland Act by property rights advocates, which explicitly prohibited HOAs from enforcing covenants on non-member properties and imposed criminal penalties for HOA board members who engaged in harassment or illegal enforcement actions. Similar legislation was introduced in 6 other states. I used part of the settlement money to upgrade my ranch infrastructure, including a backup water system to ensure that no one could ever threaten my livestock's water supply again. I also donated $50,000 to a legal defense fund for property owners fighting HOA overreach, figuring that if my case could help others stand up to bullying, the whole ordeal would have been worth it. Richard and I stayed in touch, and he continued to represent me on general business matters. He also took on several other HOA cases, always with a gleam in his eye when he talked about taking down overzealous board members. Patricia Henderson completed her community service at an animal sanctuary outside Billings, where by all accounts she actually did good work and seemed to develop genuine remorse for what she had done. She paid the restitution as ordered, took a job managing a storage facility, and kept a low profile. I heard through Howard that she eventually moved out of state to start over somewhere else where her criminal record and reputation were not as well known. The civil case against her personally settled for an additional $500,000, paid mostly by selling her house and liquidating her retirement accounts. That money went into a trust fund I established for Montana ranchers facing legal challenges from encroaching development and HOA overreach. By the time spring rolled around again, almost a year after Patricia had locked my water valve, life on the ranch felt peaceful in a way it had not for years. I stood in the same spot where I had discovered the locked valve, watching water flow freely through the lines to the troughs where my cattle drank. Tommy rode up on his horse, checking on the herd like he did every morning. "Boss, you ever think about what would have happened if you had not called that lawyer?" he asked, sitting easy in the saddle. "Every day," I said. "If I had just cut the lock and moved on, Patricia would have done something else. and something else, until she either forced me out or I did something stupid that got me in trouble. Fighting back was the only real choice. You think other folks will learn from what happened? Some will, others will not. There will always be people who think that being on an HOA board gives them the right to control everyone around them. But maybe your case makes it a little harder for them. Maybe it makes people think twice. That's all you can ask for, I guess. Tommy rode off to check the western pasture, and I stood there for a while longer, listening to the sound of water flowing and cattle lowing and the wind moving through the Montana grasslands. It was the sound of home, the sound of a place where I had every right to be, doing work that had been done on this land for generations. Patricia Henderson had tried to take that away from me because she did not like the view from her luxury home. She had thought her position gave her power without consequences, authority without limits. She had learned the hard way that property rights matter, that laws apply to everyone, and that trying to destroy someone's livelihood because it inconveniences you is a crime with real penalties. I turned and walked back to my truck, ready to start another day of ranch work. The water line ran beneath my feet, buried in Montana soil, carrying water from my well to my livestock on my land. No chains, no locks, no HOA notices, just the way it was supposed to be. The legal battle had cost me time, money, and stress. But in the end, standing up to Patricia Henderson and her HOA tyranny had been worth every penny and every sleepless night. Because some fights are not just about winning, they are about drawing a line and saying this far and no further. They are about protecting not just your own rights, but the rights of everyone who might face similar bullying in the future. As I drove back toward the ranch house, I passed the Clearwater Hills entrance with its pretentious stone pillars and manicured landscaping. A few residents were out washing their cars and mowing their perfect lawns. It looked peaceful and orderly, which I supposed was what they wanted, and that was fine. People had the right to live in HO as if they chose to agree to follow strict rules about their own properties in exchange for uniformity and managed common areas. But they did not have the right to impose those rules on people who had not agreed to them. They did not have the right to trespass, vandalize, or harass people whose property happened to be nearby. And they especially did not have the right to endanger livestock because they found ranch operations aesthetically displeasing. Patricia Henderson had forgotten that fundamental truth, and it had destroyed her life. The $2.8 million total payout from the settlements and restitution had come from HOA funds, insurance, and Patricia's personal assets. The legal fees had probably added another $500,000 on top of that. The Clearwater Hills HOA had been forced to levy a special assessment on all homeowners to rebuild their reserve fund, which had not made anyone happy. And Patricia herself had lost her marriage, her home, her reputation, and her freedom. All because she could not stand the sight of a working ranch next to her luxury development. I pulled up to the ranch house and saw my dog, a border collie named Ranger, waiting on the porch. He jumped up excitedly when I got out of the truck, and I spent a minute rubbing his ears and telling him he was a good boy. Simple pleasures, simple life. Exactly what I wanted. My phone rang just as I was heading inside. It was Richard. "Frank, I wanted to let you know that the check from the insurance company cleared. The full settlement amount is now in your account." "Thanks for letting me know. And Richard, thank you for everything you did on this case. I mean it. You saved my ranch and probably my sanity." "That is what lawyers are for, Frank." "Well, that is what good lawyers are for. You know, this case is going to be taught in property law classes for years. I've already had 3 law professors contact me asking for permission to include it in their curriculum." "Great. So I get to be a cautionary tale for law students?" Richard laughed. "More like you get to be an example of what happens when someone stands up to institutional bullying and wins. That is not a bad legacy." After we hung up, I sat on the porch for a while, Ranger beside me, watching the sun move across the sky toward afternoon. The cattle were scattered across the pasture, grazing peacefully. The water lines hummed quietly underground, doing their job without interference. Everything was as it should be. A year ago, I had been dealing with constant harassment, threatening letters, and the stress of wondering what Patricia Henderson would do next. Now she was a convicted felon on probation, banned from ever serving on an HOA board again, and I had enough money to secure my ranch's future for years to come. The turnaround had been dramatic and complete. But the real victory was not the money or even Patricia's conviction. The real victory was that I could stand on my own land, run my ranch the way I saw fit, and know that the law protected my right to do so. The real victory was that HOA boards across Montana and beyond now knew there were consequences for overstepping their authority. The real victory was that maybe, just maybe, the next rancher or farmer or property owner facing similar harassment would remember my case and know that fighting back was possible. I thought about all the people who had reached out to me during the case, sharing their own horror stories about HOA overreach. Some of them were now pursuing their own legal actions, inspired by what had happened with my case. A few had even hired Richard to represent them. The fight against HOA tyranny was bigger than just me and Patricia Henderson. It was a broader battle for property rights and personal freedom against the mindset that said conformity and control were more important than individual liberty. As the afternoon wore on, I got back to work. There were fences to repair, equipment to maintain, and 1,000 other tasks that came with running a 500-acre ranch. It was hard work, honest work, and exactly what I wanted to be doing. No HOA board meetings, no architectural review committees, no restrictions on what color I could paint my barn or what type of vehicle I could park in my own driveway. Tommy and the other hands wrapped up their work around 6, and we all gathered at the ranch house for the weekly dinner I hosted for the crew. It was a tradition I had started years ago, a way to build camaraderie and show appreciation for their hard work. Tonight we had steaks from our own cattle, potatoes from a local farm, and beer from a Billings brewery. "Boss, I've been meaning to ask," said Martin, one of the younger ranch hands, as we ate. "What did you end up doing with all that settlement money? I mean, besides the ranch improvements?" "Set up a legal defense fund for other property owners fighting HOAs," I said. "Donated to some conservation groups working on property rights issues. Paid off some debt. Put a good chunk in savings for the ranch's future. And I'm thinking about expanding our operation, maybe buying another 100 acres to the west if the price is right." "So you're not retiring and moving to Hawaii?" Tommy joked. And leave all this?" I gestured at the ranch stretching out around us, the mountains in the distance, the big Montana sky overhead. "Not a chance. This is home. This is where I belong." After dinner, as everyone headed home, I walked out to the eastern pasture one more time. The sun was setting, painting the sky in shades of orange and purple. I could see the lights of Clearwater Hills in the distance, tiny dots of illumination in the gathering dusk. Somewhere over there, Patricia Henderson's former home stood empty, a testament to how badly someone could destroy their own life through arrogance and overreach. I did not take any pleasure in her downfall, not really, but I could not deny a sense of satisfaction that justice had been served, that the legal system had worked the way it was supposed to, and that property rights had been upheld. Patricia had committed crimes, and she had faced consequences. The HOA had overstepped its authority, and it had been held accountable. That was how it should work. As I stood there in the fading light, I thought about something Richard had said during one of our meetings. He had told me that the most dangerous people were not those who intentionally set out to do evil, but those who convinced themselves that their cause was so righteous that normal rules and laws did not apply to them. Patricia Henderson had convinced herself that protecting property values and maintaining aesthetic standards justified any action, including criminal trespass and endangering livestock. She had wrapped her tyranny in the language of community service and homeowner protection, which made her feel righteous even as she broke the law. That was the real danger of organizations like HOAs. They gave ordinary people a little bit of power and a little bit of authority, and some of those people could not handle it. They became petty tyrants, using their position to control and bully others, all while convincing themselves they were doing good work. And because they operated in a framework of legal-sounding procedures and official documents, they could make their victims feel like resistance was futile. But resistance was not futile. Standing up to bullies was possible. The law was on the side of property owners who had not agreed to HOA covenants, and lawyers like Richard Brennan existed, who were willing to take on these cases and fight for individual rights against institutional overreach. I walked back to the ranch house as night fell completely, feeling more at peace than I had in years. The battle was over. The enemy had been defeated. My ranch was secure. And somewhere out there, hopefully, other property owners were learning from my experience and finding the courage to stand up to their own HOA tyrants. The next morning, I woke to find an email from a television producer in Los Angeles. They wanted to do a documentary about my case, part of a series on HOA horror stories and property rights battles. I forwarded it to Richard, who called me an hour later. "Frank, you are famous now. This is the third media request I have gotten this week. Are you interested in doing any of this?" "Not particularly," I said honestly. "I just want to get back to ranching without any drama. But if talking about the case helps other people stand up to HOA bullying, I will consider it. What do you think?" "I think you should do it. Your story has already made a difference, but the more people who hear about it, the better. And frankly, these stories need to be told. Too many people suffer in silence because they think they cannot fight back against their HOA. I agreed to do one interview with a national news program, figuring that would satisfy the media interest and hopefully help spread the message about property rights. The interview was conducted at the ranch, with cameras capturing the very water valve that Patricia had locked, the cattle grazing in the background, and the Clearwater Hills development visible in the distance. The interviewer, a veteran journalist named David Chen, asked good questions about why I had decided to fight back rather than just accept the harassment. "Because accepting it meant giving up," I said, looking directly into the camera. "It meant letting someone with no legal authority control my life and my business. It meant setting a precedent that HOAs can do whatever they want to whoever they want, regardless of the law." I fought back because someone had to, and because I had the resources to do it. Not everyone does, which is why cases like this matter. They set legal precedents, they send messages, they remind HOA boards that they are not above the law. "What would you say to someone facing similar harassment right now?" David asked. "Document everything. Keep records of every interaction, every letter, every incident. Consult with a property rights attorney early before things escalate. Know your rights and do not be afraid to assert them. And remember that HOA covenants only apply to properties that agreed to them. If you are not part of the HOA, they have no authority over you, no matter what they claim." The interview aired 2 weeks later and was viewed by millions of people. My email inbox exploded with messages from property owners across the country sharing their own HOA horror stories and asking for advice. I could not respond to them all individually, but I created a resource page on the ranch website with links to property rights organizations, information about legal protections, and Richard's contact information for anyone needing legal representation. The case also caught the attention of state legislators. I was invited to testify before a Montana legislative committee considering reforms to HOA law. I spent an afternoon in the state capitol in Helena, telling my story and explaining why stronger legal protections for non-HOA property owners were necessary. The bill that eventually passed, which the media called the Sutherland Act, included several important provisions. It explicitly prohibited HOAs from enforcing covenants on non-member properties, created civil penalties for HOA boards that engaged in harassment of non-members, and established a state office to investigate complaints about HOA overreach. It was not perfect, but it was a step in the right direction. 6 months after Patricia's sentencing, I received an unexpected letter in the mail. It was from Patricia herself, written from her new home in Idaho where she had moved to escape her Montana reputation. The letter was handwritten, several pages long, and surprisingly introspective. She wrote about how being HOA president had given her a sense of purpose and control after her children had grown up and moved away. She admitted that she had become obsessed with perfection and order, using the HOA as a way to impose her will on the world around her. She acknowledged that she had been wrong to target me, wrong to trespass on my property, and wrong to endanger my livestock. She wrote that losing everything had been devastating but also clarifying, forcing her to confront her need for control and the harm it had caused. She did not ask for forgiveness or try to minimize what she had done. She simply wanted me to know that she understood, finally, why her actions had been wrong and that she was trying to become a better person. She ended the letter by saying she hoped I had found peace and that she was genuinely glad my ranch was thriving. I read the letter twice, then filed it away in the folder with all the other documents from the case. I did not respond, figuring she was not looking for a reply and I had nothing more to say to her. But I was glad, in a way, that she seemed to have learned something from the experience. Personal growth and genuine remorse were better outcomes than bitter resentment, even if they came too late to undo the damage. As the one-year anniversary of the water valve incident approached, a local reporter asked if I would do a follow-up story about where things stood. I agreed, curious myself to reflect on everything that had happened. Standing in the same spot where I had discovered the locked valve a year earlier, I told the reporter about the ranch's success, the legal reforms that had passed, and the ongoing impact of the case. "Looking back, do you regret fighting back the way you did?" the reporter asked. "It must have been incredibly stressful and expensive." "The settlement more than covered the expense," I said with a slight smile. "And as for the stress, yes, it was incredibly difficult. But not fighting back would have been worse. Living under constant harassment, always wondering what Patricia would do next, feeling powerless on my own property. That was destroying my peace of mind. Fighting back gave me control of the situation. It let me stand up for my rights and the rights of everyone who owns property near an HOA. So no, I do not regret it at all." The reporter wrapped up the interview, and as the camera crew packed up their equipment, I looked out over my ranch with deep satisfaction. The cattle were healthy, the water flowed freely, and I could operate my business without interference from people who had no authority over me. That was all I had ever wanted. Life moved on. The seasons changed. The ranch continued its rhythms of work and rest, planting and harvest, birth and death. Tommy eventually married his longtime girlfriend and bought a small place of his own nearby, though he continued working as my ranch manager. Martin proved himself capable and was promoted to assistant manager. New hands came and went, learning the trade and moving on, and through it all, the water flowed. The valve sat unguarded and untouched, a mundane piece of ranch infrastructure that had briefly become the center of a legal battle worth millions of dollars. I passed it almost every day, usually without giving it much thought, but sometimes I would stop and remember that morning when I found it locked and chained, and the decision I had made in that moment to fight back rather than submit. That decision had changed my life and, in a small way, had changed the landscape of property rights law in Montana and beyond. Other cases followed mine, other property owners standing up to HOA overreach, citing the Sutherland case as precedent. The Montana Supreme Court eventually ruled on an HOA case that established even stronger protections for non-member properties, referencing my lawsuit in their decision. Patricia Henderson's name became synonymous with HOA tyranny in property rights circles, a cautionary tale told at legal conferences and in law school classrooms. The Clearwater Hills, HOA, became more moderate and reasonable under new leadership, focusing on managing common areas and actual community concerns rather than trying to control everything visible from HOA properties. As I sit here now, writing this all down, it has been more than 2 years since Patricia locked my water valve. The ranch is more successful than ever. The settlement money, invested wisely, provides a comfortable cushion for the business. The legal defense fund I established has helped 3 other property owners fight their own HOA battles, winning 2 cases and settling the 3rd favorably. I still live in the same ranch house, still wake up at 5 in the morning, still spend my days doing the work I love on land I own. The difference is that now I do it without looking over my shoulder, without waiting for the next HOA citation or complaint or harassment. Patricia Henderson taught me an important lesson, though not the one she intended. She taught me that standing up to bullies works, that the legal system can protect individual rights against institutional power, and that sometimes the right fight is worth the cost. The water valve sits in the eastern pasture, rust-free and well-maintained, doing its job day after day without drama or incident. No chains, no locks, no threatening notices. Just an ordinary piece of ranch equipment on my property, controlled by me, serving my cattle and my business. exactly as it should be. And that, in the end, is what the whole fight was about. Not the money, not the publicity, not even the satisfaction of seeing Patricia Henderson face consequences for her actions. It was about the simple right to own property, operate a business, and live life without interference from people who had no legitimate authority. It was about drawing a line and defending it, not just for myself, but for everyone who might face similar challenges. The sun is setting now over the Montana landscape, painting the sky in those familiar shades of orange and purple that I never get tired of seeing. Somewhere to the east, the lights of Clearwater Hills are beginning to twinkle as residents return home from work, mow their lawns, and live their orderly HOA-governed lives, and that is fine. They have the right to live that way if they choose. But out here on the ranch, under the big sky, with cattle grazing and water flowing and land stretching to the horizon, I live by different rules. My rules. The rules I agreed to when I bought this property, drilled this well, and built this operation. No HOA president can change that, no matter how powerful they think they are, or how righteous they believe their cause to be. Patricia Henderson learned that lesson the hard way. The Clearwater Hills HOA learned it too. And hopefully, through the publicity and legal precedents and legislative reforms that followed, other HOA boards across Montana and across the country learned it as well. Property rights matter, individual liberty matters, and sometimes when those things are threatened, the only choice is to fight back with everything you have. That is what I did, and I would do it again in a heartbeat. Because some battles are not optional, some lines cannot be allowed to be crossed, and some fights are worth every penny, every sleepless night, and every moment of stress, because they are about more than just the immediate issue. They are about principles that matter, rights that must be defended, and freedoms that, once lost, are nearly impossible to reclaim. I turn away from the sunset and walk back to the ranch house, Ranger trotting beside me, ready for dinner and rest after another good day of work. Tomorrow will bring new challenges, new tasks, new opportunities, but it will not bring HOA harassment, illegal interference, or threats to my property rights. Patricia Henderson made sure of that when she decided to lock my water valve and discovered that some people, when pushed too far, push back harder than anyone expected. The ranch is quiet in the evening calm, peaceful in a way that money cannot buy and HOA rules cannot create. This is home. This is freedom. This is what I fought for. And this is what I won. And every time I turn on that water valve and watch it flow freely to my cattle, I am reminded that standing up to tyranny, no matter how petty or local, is always worth the fight.